May I please, my lord? My lord, I beg to mention one BA, BA number 23, 2026, which is pending since months. So matter may be listed for day after tomorrow. Oblige, my lord.
May I please, your lord? Lordship, I beg to mention this item number 23.
Item
23, Lordship.
2,
3.
3.
Lordship. Lordship, kindly this matter may be heard on this 18 of June. That is on 3rd.
You are for the
I'm
petitioner.
for the appellant, your Lordship.
Appellant, this is this
Here,
appeal
CRP. I'm for the petitioner, Lordship.
petitioner. Mr.
J. Saro.
Learned counsel for the petitioner. Now, on the prayer of Mr. J.
Saro.
Learned counsel for the petitioner, list his matter on 18.
Lordship, 18.
Okay. Why 18? June 18. 18 is Thursday, DB day. 17. Okay.
Lordship, obliged.
Item number 1.
Please, Lordship. Here we are assailing the order of the learned special judge ACB, which is at page 15. There were several petitions, applications filed for defreezing of bank account. So in that manner, several matters have been disposed of together, and all the matters are totally jumbled up. Here we are concerned with the present petitioner's bank account number, which is a salary account. The only thing in this case is, Your Lordship, she is not an accused person in the case. What happened? One of his relatives, Your Lordship is aware, in Arunachal Pradesh, the women groups, they form some groups and lend money. And she also lent money to the wife of that accused person.
I'm not aware.
No. Anyway, so what happened that when the husband got the money, on behalf of the wife, she returned the amount with interest of rupees of 5 lakhs. That is the only ground for freezing of this her salary account. That's the only ground. And the learned court below has not given any proper reasons for disallowing that application, because all the other applications have been mixed together, and it is shown that some 80 lakhs or something has been
Issue
deposited.
notice and call for record.
Yes, ma'am. Not CD, it would be necessary because
The instruction will be necessary.
Yes.
Because, my lord,
So with regards especially.
yes,
yes,
specifically for this one, ma'am.
it pertains to that Lada
Trans
case.
highway.
Trans
or-
Yes,
sir,
yes.
There has been so many,
Yes.
misappropriation. And it seems this money,
Accounted, unaccounted amount.
yes.
So you-
it has
No,
come to
only
the-
5 lakhs that learned court below has also agreed, ma'am. Only 5 lakhs has gone to the account of this present petitioner.
And you say, according to you, it is a loan amount.
Yes.
But according to us, it is
Yeah.
the amount which was given to her by the broker.
But anyway, my lord, the motto of freezing account is that the my lord, amount which is illegal or my lord, gotten money, that shouldn't be spent for any other purpose. My lord. For that, it cannot be that the salary account itself be freezed forever. My lord. It can be done like this.
They wanted that you should have a,
My lord,
open a new account.
My lord,
For that.
it can be done like this, my lord. If suppose they say 5 lakhs has gone to the account of the petitioner,
No,
they can say freeze that amount only. Rest salary, he should be allowed to draw, my lord.
Okay.
Anyway, my lord,
Mr.
of course, notice
Pitapho, Learned Senior Counsel, assisted by Ms.
M. Karbat,
Mm.
MS M. Karbat.
Learned Counsel for the petitioner. Also had Mr. Opada, Standing Counsel for SCB. Start para.
Extra copy.
This, by filing this application under 442 of the VNS, the petitioner assailed the order dated 27 2026 passed in miscellaneous application number 31/2026 in ACB PS case number 13/2025. Whereby your prayer was rejected.
Yes, ma'am.
Where is the operative portion? In the
Page 15, 16, 17. Page
Page
17.
70.
17, madam.
Last paragraph.
your account number is
My account number is my lord, 1187 6527370.
SBI. madam.
Yes, SBI account.
whereby the praying for defreezing of SBI account number 1187 6527370.
Yes.
SBI,
Yes, SBI.
SBI account number, huh? Has been rejected, huh? Stop, huh? We'll say just you'll obtain instruction only, no notice.
But notice may go.
Notice,
Okay,
Issue notice.
okay, issue notice.
Yes.
Since Mr. Opada, Lanet, standing counsel for ACB, accepted notice, no formal notice need be issued. Any other respondent? No,
No,
no, madam.
okay. Call for, well, then we'll call for the case. That
yes, ma'am.
Yes,
is
madam.
it still under investigation?
Investigation.
Yes,
okay?
madam.
Okay, call for the. Okay, call for the case study. Stop, and list method again on,
After,
2 weeks, my lord.
after, okay. Release,
my lord, extra copy will be given to me
Yes,
so that I can inform the officials, my lord.
okay. What may be given?
Extra.
Extra copies, my lord.
Okay,
Definitely we will
then
serve.
however, the
Today itself,
petitioner
sir.
shall furnish requisite extra copies to the learning council appearing in behalf of the respondent. Stop para. List is matter after 2 weeks.
Yes, much obliged.
Legally obliged, madam.
Item number 2.
Yes.
Noted this anticipated bail application, subsequent bail application. Earlier
Okay.
bail application was rejected by this honorable court.
List code rejected.
Yes. Page number 53, the order.
Okay, thereafter,
Thereafter,
what happened?
now. Yeah.
Any changes?
For this only ground is, he is in rehabilitation. Page number 56 is there
Rehabilitation for
Yeah.
what?
for substance use disorder. Since 26/5/2026. Page number 56. Page number 26, 56.
No, so this is in connection with you are seeking a pre-arrest bail in connection with which case?
In connection with.
Is this also in connection with the rehabilitation for what? Is rehab center for what?
For substance use disorder.
Okay.
He is currently admitted there.
So here also he was registered under NDPS.
No. No,
This is different.
different matter. Here it is, the sections are 127(2) wrongful confinement, 135 assault or criminal force in attempt to wrongful confine.
Yes,
Person-
the allegation was different,
Yes.
but then now he has landed to the rehab
Yeah,
center.
he has substance
Okay.
disorder as well, so he is currently in rehabilitation.
Seems you are in the trouble.
Yes.
It seems you are in trouble. This appears the now. And then although he is in rehab center, but the police failed to, police could not find him.
Your Lordship, as soon as Your Lordship's, the bail was rejected on 25/2026, he got admitted on 26/5/2026 as per the documents, Your Lordship.
26?
The bail was rejected on 25,
Yes,
Your Lordship,
uh.
and he got himself admitted on
Okay.
26/5.
okay.
As soon as the bail was rejected, he got himself admitted in the rehab center, Your Lordship. And therefore,
Okay, wait till he come up. So what to do?
Your Lordship, otherwise, since Your Lordship on the earlier occasion.
No, any cases registered against him for under NDPS?
No, no.
This is the only case, and on the last occasion we have detail regarding there is certain.
But here in this case, he's not entitled. I have seen. He's not entitled. There is a deliberate,
Yes.
and you see person coming from there, threatened, beaten, all those taken.
Mm.
See, that we cannot
Uh,
protect.
For that reason,
Hmm.
the same was rejected by this honorable court.
Yeah.
Now only on the ground that he is currently in rehabilitation for
Uh,
that he is seeking.
Now we need to ensure
Yes.
what for he has admitted himself in rehab center. Is known person, unknown person, or so what to do?
I would suggest, Your Lordship, since his admission is for 3 months, Your Lordship. Till 3 months, because on the earlier occasion, the AV, Your Lordship has seen that case diary and Your Lordship felt not appropriate to give him the privilege of bail, Your Lordship. Now, since he has got admitted by his own self without any cases for substance abuse, Your Lordship, and he has been admitted for 3 months, Your Lordship. Your Lordship can keep this AB pending for 3 months because it seems that he's in the rehab center, Your Lordship. And meanwhile, get report from this rehabilitation center, Your Lordship. Because if Your Lordship, if Your Lordship even grants an interim, since he is to be
No,
treated for,
interim, he is not
yes,
entitled.
supposedly, Your Lordship, if his treatment, he has to go under treatment for 3 months, Your Lordship. Once any interim or any bail is there, I don't think so that he'll complete 3 months. He'll be out of the rehabilitation center, Your Lordship. There is also nothing as to ascertain except for this documents, Your Lordship. So if I may suggest, Your Lordship can keep this AB pending, Your Lordship, and then get the status report from this rehabilitation center. The update of the
So we can
patient, Your Lordship.
call for the status from the rehab center. State.
No, police, probably the IO also knows. He has admitted himself.
I'm not much aware of the case, Your Lordship.
Now, if there is any procedure to record his statement, etc., if possible,
Because
making a appropriate application.
yes, because on the previous occasion, Your Lordship, you see that he was absconding, Your Lordship.
Hmm.
Now, this is the first time even the prosecution has come to know that he has been admitted, Your
Mhm.
Lordship. Now, I'm not,
Okay. Then, okay, Mr. J. You are not key, you are sharing, sorry. Then counsel for the petitioner, also had Mr. Genie, then additional PP for the state. At the outset, the line counsel for a petitioner submit that earlier by an order dated 25/2026, this court has rejected the prayer for granting rearrest bail to the accused applicant in connection with the Nirjuli PS case number 14/2026 under section 127(2), 135, 117(2), 121, 143, 308, 5, 351(2), 35 of the Bharatiya Nyaya Sanhita 2023. Is there any other, I think there are some other accused also in this case? Was it only him?
There's other unknown individual, FIR
Okay,
says some unknown
okay.
individual as well.
Mhm. And this is the second round of, sorry, this is a subsequent application seeking pre-arrest bail, apprehending his arrest in connection with the aforesaid PSK, Nirjuli PS case. Staff. The Learned Counsel for the petitioner submits that although there is no any changes in circumstances of the case, however, the accused applicant, after rejection of the earlier anticipated earlier pre-arrest bail, has got himself admitted in the rehab center where?
Serin Rehab Center at Nirjuli.
Which paragraph you have given?
Lordship will see at page number 56.
These are 56 annexed.
56.
Yes. Name of the rehab.
Okay. Rehab center name, namely Shirin Rehabilitation Center, within bracket Nasa Mukti Kendra, bracket close. B sector Nirjuli. Where he is to go undergo a treatment for 3 months. For what do we call it? His suffering is called it?
Yes. Chronic substance use disorder.
Okay. For chronic substance use disorder with effect from, this would be with effect from 26 5/2026. Stop on para. Okay, issue notice since Miss Jenny accepted notice on behalf of the state, no formal notice need be issued. Stop para. Miss Jenny prays for some time and prays for submit that this just take prays for some time to obtain necessary instruction in this regard. Okay, we'll say instruction.
yes.
Okay, stop. Age prayed for comma list is matter when after
Today's on 26, Your Lordship.
26.
Yes.
26 of this month.
Since he is in rehabilitation, only till that he will be protected.
No, Your Lordship.
Otherwise,
He is already
That is-
protected there.
that
He
is-
is already
is-
protected there.
Yes.
He will be
Yes.
arrested from the rehabilitation time.
He is already.
He's already,
protected there.
his bail has already been rejected on a regulation. This seems to be
Let us see.
well planned.
And then if required, let us see if he required to be tested. Okay,
deeply.
All right.
Item number 3.
My lord.
Yes.
My lord, this item number 3 and 4 can be taken up together because this is arising out of same FIR.
Okay.
Your Honor, this present application, these two applications has been filed under after apprehending the arrest due to police notice dated 26/5/2026. My lord, I straightly come to the FIR, my lord, which is at page number 13, Annexure 1. May I read the FIR? With due respect and regard, the undersigned being deeply aggrieved by the act of the above alleged accused person would like to submit necessary complaint for immediate action. That I am the proprietor of MS Kiko Enterprise, a permanent resident of so-and-so, Alo. Alleged persons were known to me through my colleague. That on the month of August 2024, I kindly note that Mr. Syam Ghatani, son of so-and-so, and Bhuvan Nath, son of so-and-so, approached me stating to have expertise in GST related matter and offered to handle all GST and other tax related matters of my firm. As such, on good faith and trust, I engaged them under my firm to handle the technical matter stated above. That a complainant begged to state that for the month and year 2025 August 2024 to 7 February 2025, I had paid a total amount of rupees 57 lakh only for making payment of GST and other taxes against my firm to Sri Syam Ghatani and Bhuvan Nath. And furtherance, the alleged person have also forwarded several fake tax invoices against my firm name during the course of time. Thereafter, surprisingly on 17/5/2025, I have received a summons from Office of the Directorate General of GST Intelligence Guwahati warranting for making default of payment of GST and other taxes, including my firm, against my firm. As such, I inquired about the same to the alleged person, Sri Syam Ghatani and Bhuvan Nath. They have admitted to have default in payment of GST and other tax and dishonestly misappropriate the amount handed over to them for the personal use and gain. And also in due course of event, they had cleverly furnished fake GST input to me. Further, to that effect, they have also executed self-declaration affidavit dated 9/2/2026 and deed of agreement dated 9/2/2026. That the conduct of the alleged person was with sole intention to commit offense of cheating by claiming to have expertise in GST and other tax related matter and to deliver a total amount of rupees 57 lakh only for paying GST and other taxes against my firm, to commit offense of criminal breach of trust, dishonest misappropriation by virtue that the alleged persons were engaged as staff under my firm. However, they dishonestly misappropriate the amount so they received for making payment of the GST and taxes, other taxes to their own personal use and gain. Furthermore, they have also engaged in forging tax invoices against my firm and furnished the same to me. Hence, considering the above facts cited, the undersigned being deeply aggrieved by the act of so-and-so, your good office requests us to register an FIR against the alleged person and take immediate action against them for willfully committing offense with intention to gain wrongful monetary benefit from innocent by way of cheating. And I also humbly request your good office to book them under appropriate provision of law for interest of justice. This is this FIR, you know. 2-3 points which I would like to point out, which will be important for deciding this anticipatory bail application, Your Honor. First thing, Your Honor, the alleged offense was occurred during the period of 2020, August 20, on 25 August 2024 to 7 February 2025, within a period of 6 months, Your Honor. Second point, second thing, the information about the offense came to the knowledge of the complainant on 15 5 2025. That is May 2025. Upon receipt of summon from GST agency, Your Honor.
How the complaint was,
May kindly
FIR
note,
was lodged only on 26.
Yes,
How he
2000.
came to know about 2025?
in FIR it is written, Your
Hmm?
FIR it is written. Page number 14, Your Honor. The portion of FIR,
Who came to know about this?
the complainant, Your Honor.
Okay, complainant.
Yes. So
When he came to know?
he came to know on 17 5 2025, Your Honor. 1 year back, Your Honor. And he undertook self-inquiry, admittedly, whereby he said that the
Yes,
person,
because he was furnished a fake GST.
yes. And he,
That is why he wanted to confirm.
yes, he said he,
After confirmation, probably he filed this FIR.
yes, Your Honor. He said in this FIR, he says, yes, they have admitted, Your Honor. Now, Your Honor, third point, Your Honor, there is an existence of agreement dated 9 February 2026, Your Honor. To my understanding, Your Honor, what has happened, Your Honor, there were some irregularity in irregularity or mismanagement of fund of the firm, admittedly, Your Honor. And there were an attempt of settling the issues, which clears from the agreement dated 9 to 2026, Your Honor. Now, once there was an offense at that point of time, Your Honor, and by entering into this agreement, Your Honor, the complainant has, to my understanding, had condoned the offense.
Where do we find?
Allegation, Your Honor,
What is some of the things?
agreement is 9 February 2026, Your Honor.
Whether tax already paid? No,
No,
tax not yet paid.
no, Your Honor. Why? Because this agreement,
Then
this agreement was executed on 9 February 2026, and the accused was given 1 month time to repay the amount. And may kindly see the amount. Your Honor, amount in that agreement is 3 crore, Your Honor. 3 crore 12 lakhs, 87,855, admittedly. And what is informed by the accused person, Your Honor, to me, this amount, such a huge amount, to arrange such a huge amount, it is taking some time. So in the meantime, what they have done is, Your Honor, they have obtained a post-dated check from me, the accused person, and they got it bounced, dishonored, and served me legal notice. So basically, what is happening, Your Honor? After serving that legal notice, this FIR was registered, Your Honor. So what is happening? Everything is being set into motion, Your Honor. So my argument would be, Your Honor, the existence of this agreement dated 9 February 2026 makes this issue into a civil dispute, Your Honor. Purely civil dispute.
I have no idea. Non-payment of tax is a civil.
Yes, Your Honor. Now,
Mm.
Your Honor, my,
And cheating the person
yes, Your Honor.
by giving a fake GST certificate
Yes, Your Honor,
is
that is,
civil dispute.
yes, that is allegation only at this stage, Your Honor.
PP will be able to tell.
So my limited ground of
Okay.
availing this application, Your Honor.
So
I am
call for the case diary. Case registered already.
yes, sir.
When it was registered, you said? May. Okay. Pardon, Mr. Tiomo. Land counsel for the petitioner. You have a complaint. Okay.
Lordship, so I may be allowed to make submission, Lordship.
What submission you want to make now?
Objects, Lordship, the bail objection, making objection for submission made by the
Okay.
bail applicant, Lordship. Lordship, is the learned counsel for the applicant, submitted that it is a civil in nature, Lordship. Lordship, of course, the gist of the case is the transaction of 57 lakhs, Lordship. However, the alleged two accused persons has duped the 57 lakhs, and they have produced lots of tax documents, Lordship. So
You just tell, first you tell whether the tax already paid or not.
not
You also will be liable. Then in that
actually,
case.
actually, Lordship,
Huh.
I was believed that I have deposited
Both will be liable.
some
It will be
amount to
difficult.
two
Mm.
accused person, Lordship. So I was believed that my tax was fed by these two accused person, Lordship. However,
We'll call for the case diary first. Okay.
My lord,
Oh.
till the,
Also hard, Mr.
till that some protection,
Lorry, land
no
PP for
coercive
the
action,
state.
till returnable.
By filing this application under section 482 of the Bharatiya Nagarik Suraksha Sanhita 2023, the accused petitioner is praying for granting pre-arrest bail, apprehending his arrest in connection with Alo PS case number 20/2026 under section 61, 2, 316, 2, 318, 336, 338, 342, BNS 2023. Original not required. We would like to see the case diary first, huh? So, since Mr. Loy Lana PP issue notice, huh? Since Mr. Loy Lana PP appear and talk for some time to obtain instruction. No, Mr. Loy, huh? Lana PP accepted notice on behalf of the state and sought for some seek some how much time? Scan copy of the case diary. Stop list this matter after a week.
Your Honor, some interim protection because I have yet to appear before the investigating authority and I'm apprehending arrest, Your Honor. So let me appear before the IO of the case, Your Honor, so that otherwise there will be no purpose.
You appear before the eye
Yes.
of the case.
No coercive action.
If the person is not entitled, he has to go only. It doesn't mean that in all the cases, the petitioner will be protected. It's not like that.
Your Honor, some protection because
Only the
I am
whosoever file will get the interim, or otherwise the no
Yes, sir.
purpose will serve. It's not like that.
Yes, Your
Hmm.
Yes, but Your Honor, in this case, my lord, I am ready to cooperate with the investigation, but,
You should be.
and I am not even denying the amount, and I'm ready to repay the amount, my lord.
See, in both cases, both now the tax has not been paid. Both probably. One for non-payment, one for, of course, duping, and then both will be liable, it appears. Paid to you. It was you who was deposited, and you have
Yes,
never
my lord. And they
deposited.
have quoted, they have registered a case, and let me produce the document, let me give an explanation to the IO, my lord.
You mean to say you have paid the tax?
That is, that.
And you said that you have admitted the money,
No,
and then you have
I
not
have
paid tax.
received that
What is
amount,
this?
allegation of 57 lakhs, that
Hmm.
the agreement says that I admit that amount.
Yes, that you have admitted.
Then I'm ready.
And that is why I'm saying the offense complete there. You were to pay tax on behalf of the informant and receive the money 57 lakh. You did not pay. The state is suffering now.
Now, to my
Now,
understanding,
in the admitted case, how can you expect that you'll be granted bail or anticipatory bail when the offense itself has been admitted by you?
my lord, that admission of offense, because for that, my lord, there's for that, a complaint has to be registered first, Your Honor. And that complaint, the inordinate delay in lodging this.
What
FIR,
is this? What is this FIR?
But my lord, the
What according to
duration-
you this FIR is?
duration of lodging of this FIR says that it-
Oh, now you yourself say that it was, he came to know later on, and then thereafter he himself has investigated, he himself wanted to know whether it was paid or not. He was informed that not paid, but he wanted to confirm it himself. That is why it took time, it appears.
no, my
And thereafter he lodged a FIR.
no, my lord, his knowledge about the incidents in 2005, my lord. May kindly see the timing, my lord. What has happened in between 17/5/2005 to 5/5/2026, Your Honor. It says, it appears that there were some attempt of settling the issue. Says
The learned counsel for the petitioner.
some
submitted-
protection, my lord.
When you are called,
I was
when you were supposed to appear before the police,
my lord, with protection, I will appear anytime.
when you were supposed to appear, where is the notice?
This notice says on 30th June, my lord, May.
That also is gone.
Yes, my lord. So within 2-3 days, I will appear, my lord. Till then, at least some protection, my lord.
No, it appears you are a trouble man. We'll call for a case study, okay?
Obliged.
One o'clock was. Okay. Okay, we'll issue notice.
Yes,
Okay. Call for the,
Lordship,
Mr.
N. Kumar, Lordship.
Learned counsel for the petitioner, staff also had Mr. Loy, learned PP for the state. Para. This application filed under section 528 of the Vardian Agri Structure Sanita 2022. No, this application under so and so has been filed jointly by the accused and informant.
Victim, Lordship, also the victim.
Victim, and who is the informant?
Informant is sister-in-law of the victim.
Which one?
This
Petitioner number?
one, Lordship, Dr.
Informant.
Yes, Lordship.
Okay, that is why. Informant, victim and accused,
Yes, Lordship.
praying for setting aside the. What is the stage of the case?
Lordship, now stage is in the evidence, Lordship, and out of 5 witness, Lordship, 2 witness already examined, that is informant and her husband.
Where you have mentioned the name of the case, number of the cases? Which court? Case
Uh,
number?
Land Court of CGM UPR, Lordship.
Where is the case number? Where have you mentioned? Seventeen? Why?
Page number 70.
GR case number 61517 arising out of Itanagar women PS case number, double PS case number 95, 2017. Registered under section 365, 34 IPC. Pending before the Court of Chief Judicial Magistrate,
Yes, Lordship, UPR. Lordship.
UPR.
No.
Stop, huh? Is to notice, since Mr. Loy, Lana PP, accepted notice on behalf of the state respondent, no formal notice need be issued. Staff, huh? Call for the scan copy of the trial court record. Staff, huh? When? List this matter next week. Okay.
Lordship, I have one humble prayer, Lordship. This
What?
matter is fixed in 26 of this month, Lordship, in the court of Land Court of CGM. So till that, Lordship, matter may be stayed, Lordship, in the Land Court of
26
CGM.
of?
proceeding. 26 of this month,
Appear
Lordship.
there,
Lordship, matter is reached in the stage of the evidence. So this time notice is issued to the victim, Lordship. So, Lordship, they have jointly filed. this
issue to the
application.
victim.
Yes, issue the notice, notice
That
is
will be
issued to the
better.
victim.
That will be better. The victim will cooperate you. Will see the record and then see, that will be better for you also.
Lordship, they have jointly.
Because
filed
now
this
the
application.
victim has no further grievances, isn't it?
Yes, Lordship.
Now she is major.
Yes, he is now 26
Now-
years and
Now let her
already
speak,
married,
let her
Lordship.
speak that I am major. I have no further grievances. That will be helpful for you, rather.
Lordship.
Okay?
Actually, they are staying in the Dolungmuk, Lordship, and she is also has some physical problem, Lordship. That's why she have agreed
Make
for this.
make a petition, application,
Lordship.
make an appropriate application. She was minor. She was minor
Yes,
at the
Lordship.
time of commission of offense.
Yes, Lordship.
How do you expect that? Okay.
Obliged.
Item number 6.
ये स्टब होगा वही करते
My pleasure.
yes
My lord, here I am putting to challenge the execution proceeding that was initiated. Of course, that was stated, my lord, that by the order dated 13/6/2023. Now, this is a long checkered history between the petitioner and the respondent, my lord, who are otherwise
substitution petition file have you filed
here, my lord. Oh, no, my lord. I'm sorry, my lord. Yeah, I'm not yet filed.
I think you have to
I forgot, my lord. Yes, my lord. I need some time then, my lord.
okay Mr. Sopi this Land counsel for the petitioner prays for further time further 1 week 2 weeks
3 weeks, my lord.
further 3 weeks time to file a substitution substitution interlocutory application for substitution of the legal heir of the sole respondent staff. The prayer is allowed. List this matter after 3 weeks. Okay, make an application.
My lord, my lord.
Item number 7.
Yes. You are for respondent or petitioner?
Lordship, my appeal has been dismissed.
Appeal or your condemnation application? Yes, say that.
I have filed condemnation application as well as the appeal, but appeal is not registered. This is the issue. But
No, how, unless it is condoned, the delay is condoned, how the appeal can be registered?
court deliver of the
By the way, this is second appeal.
second appeal. Substantial appeal.
What substantial question of law involved here? It was exercise of the discretion, power, discretionary power of the magistrate. What substantial question is involved here?
His case has been dismissed on condemnation of delay.
Yes,
Condemnation.
there I'm asking you.
Whether that condemnation description was wrongly applied or not, that is the issue with substantial question.
Oh, rightly or wrongly, he has exercised his discretionary power. Where is the question of substantial question of law arise there?
Lordship, condemn, lordship is declared. Here is every reason to condemn. Here is the reasons to condemn. Sufficient reason to condemn.
Okay, can we?
Because when it has been dismissed, when the interlocutory application, condemnation delay application has been dismissed, it, what is the remaining in that?
No, you just tell me what substantial question of law involved here while rejecting the delay condemnation petition by the judicial magistrate or the civil judge senior division. What is the substantial question involved here?
Not yet, Father.
Because what is second appeal under 100?
Lordship District Court.
Hmm.
Case was before District Court. Case has been, Lordship case has been decided in favor of the other party. So I filed an appeal against the
Yes, you file appeal, but then there was a delay of 4 days
4 days.
and then delay was not condoned,
Delay was.
rejected. So my question is what substantial question of law involved here?
Substantial question of law.
It is second appeal.
Yeah.
Under 100.
Yeah,
Can we just read once? That,
under 100,
yes.
without
What is the requirement for, what is the requirement for that?
having argument over that.
Hmm.
Argument over the
Books mo
appeal.
CPC? CPC कहाँ? मेरा है ना?
Without having argument over the appeal. When the interlocutory appeal.
No.
Condemnation of delay.
How the argument on appeal can be heard unless the delay is condoned? Delay for hearing is condoned.
That is why, when it is dismissed, my opinion,
See, you could not explain that being a Christian, how a local puja can be performed. You could not explain.
kindly see what exactly it is, kindly see, application.
और दूसरा भी
Number 19,
हाँ,
kindly
मेरा वंश को ले आना हाँ
kindly see, page number 19. The application for condemnation of delay. When the application for condemnation is dismissed by the appellate court without hearing the matter,
How in the condemnation petition, delay condemnation petition, the appeal can be heard? First of all, your delay you have to explain properly, isn't it? Delay has to be condoned. Thereafter, it will be registered and will be heard on merit.
that is why I'm submitting lawsuit. Without this, since to hear the matter,
to hear the matter, condemnation delay at the, it was the issue. Whether that rejection was illegal or rejection was
Rightly or wrongly, it was decided by exercising his own his discretionary power.
that is why that has to be examined and reported honorable court.
What examination? What is to be examined there?
Itself is a substantial question of law in terms of daily.
Oh,
That itself
see,
is-
when the discussion come, how it forms a substantial question of law?
I have the judgment.
What judgment? What it says?
Rejection of the interlocutory application,
Hmm.
rejecting the condemnation delay without proper hearing.
Hmm.
Itself is a
Okay, show me.
that is. 2020. 15 days. 123.
Hmm.
And paragraph number 14.
Highlight it, mark it, highlight it. Hmm.
And another Sam Sundaran, Pannalam Idashwar. It is 2005, 183, 456. And paragraph 13.
Para? Shyam Sundar?
Report Sam Sundar, can you see the, that's why, 2020, 1583, 120, paragraph 14, 11 and 14. It's crazy.
Hmm.
Vijayanath,
Oh,
Apsara Begum.
Vaizinat.
Because when the law field, when the matter is dismissed, though, when the matter is disposed, I have the exclusively right to appeal. But here are the 4 days lapse in filing appeal. And that delay will be explained in my this interlocutory application. I have explained that it was never been argued here. That is the argument as per law.
What it says? What it says?
Page number 19.
What it says? You para 14?
Oh, I need to check that up.
Hmm.
That up. When the matter is noted, when the matter is dismissed in the appellate forum, without without hearing the matter on merit on technical ground, condemnation delay in the technical ground. That end the matter law. When it is without, when the matter is dismissed, without argument, without deciding that matter as per law, that itself form a substantial ground for appeal law. Preliminary ground, not a not a matter of merit. On technical ground.
You have come under 100 CPC.
Okay. Second appeal is always on substantial.
Yeah, that's right. That is why, what is your substantial question here? Can we just see once, what is the substantial question?
That board cannot dismiss the case. Case means that the interlocutory application.
Okay, so that means, no, you mean to say that anyone can come even after delay of whatsoever they may be.
No,
Then,
that is not my,
so the delay condemnation petition in appeal cannot be dismissed.
that is not my point.
Now, what is your point
My
then?
point-
You explain what is the meaning?
My point is,
Hmm,
when I have filed appeal, statutory appeal
yes.
against the dismissal order
Hmm,
passed by the senior division.
Hmm.
In that event, there was a delay of 4 days in filing appeal. In that case, I have to file, technically, I have to file condemnation delay of that 4 days.
mhm.
I explained the reason. There is a sufficient ground for condemnation of that delay part. However, last week, my application for condemnation of delay period has been illegally rejected, Lord. Not on merit,
How it becomes illegal?
because when that can be granted, Lord, if that can be considered, court has no absolute power to reject, Lord. That
Yes.
has to be considered.
He has exercised that power.
Court is part, court is, that is the observation, Lord.
Hmm?
Of-
No, court has passed order rejecting,
Yes,
saying that there is no sufficient cause.
Why, Lord?
Hmm.
That is subject to further interpretation before the second appellate court. Whether that rejection is right or wrong. That is here. That is the issue here. Rejection itself is appealable law. Rejection of condemnation delay application itself is appealable. Substantial question of law, as per law. Before the appellate court, before second appellate court. Otherwise, my case will end here, Lord.
It ends there only. It ends there only.
That cannot be law. There should be second appeal law. It is a second.
So that means you mean to say that there is no end for case. There shouldn't be any end for case.
There is second. Second appeal is always, there is a statutory.
No, for second appeal, you see, we are in 100
That is a statutory.
CPC.
Here.
So you have to satisfy that 100 CPC.
Substantial question of.
You,
law.
you have to satisfy the ingredient of the 100 CPC,
Yes,
isn't it?
My substantial question of law.
Yes.
Without hearing the matter on my condemnation application. On
Oh,
merit, Lordship. On
okay.
merit, Lordship.
It was not heard.
Her, but is illegally decided though.
Oh,
That is the case. That
Ille-
is why second appeal is reported honorable.
can you explain what is illegal means?
Illegal means I have explained the matter, kindly see. Page number 19 of. In the given situation, there is a various instances, Lordship, in the reported Supreme Court as the.
See, so let us see which part of the order. It's not a judgment, not a decree also, huh? For your kind of information, which part of this order is illegal?
As per section 2.
Just show
As
us.
per section 2 of the CP. When matter is still,
Hmm.
create it amount to a decree law. It creates a right before. I cannot further make further law. When it is stopped, I cannot go further.
Is it only the option of appeal?
Kindly
Which
see
you
page-
can,
page number 19, what is my ground for condemnation here? Condemnation, page number 19,
What is 19?
page number 19 of the appeal law. Second appeal. What is the
No.
ground for, my ground for condemnation of delay here?
Yes. Hmm.
What is it?
Where?
But the observation now,
See, you, Learned Council, you said illegal. Which part of the order is illegal according to you?
kindly see, this is my condemnation. And condemnation, you kindly see that read the para 2 and para 3. Page number 19 of the appeal, para 2 and para 3. Para 2 reads, the ground of delay was that he was suffering from stomach pain and other health problems after went to jungle for collection of rock and for construction of godown. As per the advice of the local Niri, the local priest, he performed a asi among the local puja, and he was restricted. It is a local as per his performance of devotion here. 7 days not to go out from his day. assess here the delay of 4 days in filing the appeal. The results of delay is without any intentional detour, they unavailable certain, therefore 4 days delay may be condemned for the end of it. That is the prayer.
See the, sir, see the prayer of other side. You were Christian and was baptized in 2016. And no question of local puja performance arise.
Time is in here, nothing else as baptized.
Could have taken some other region, some other ground.
What is? I do not find any such baptism here though. Kindly see page number. My application form.
Court have found you
One, this is the three.
giving a false,
three
false
things
statement.
in which there is nothing any mention of baptism though. Kindly see.
Given a date also, certificate also, everything. See, when the court finds someone is telling lie, it's really, really intolerable. Court doesn't tolerate it. Could have taken some other ground. That when the court found that you are telling lie, you could not satisfy the court. It's very difficult in that case. So this is, this order has been passed in exercise of his discretion only. How do we interfere with the discretion? Has it been the question of law? Of course, this court can. But then when the judge, learned court has exercised his discretion, we cannot just give a direction to exercise this way, that way, your discretion. That can be challenged, but then discretion, how do we? Hmm.
Such drafted by they call it Tamulang Taki.
Hmm.
And I'm exactly not aware of the outcome. Matter become
I've seen the record. 6 times you have taken adjournment, not yet. This should have been listed on motion. This is not yet, notice not yet issued. It was filed on 2025.
You can better explain this matter. I can.
1, 2, 3, 4, 5, 6,
Explain this matter.
8 times.
You will personally appear. So there is some technical.
Yes, eight occasion. It was, I think, now, of course.
My observation was honestly, my observation was that when the
Anyway,
play.
see, this would have been placed.
When the.
This is not in the admission actually.
Continuation delay.
Mr. Tapak, this should not have been listed in the admission because notice not yet issued.
Yeah, not.
Prayed for, senior is not there due to some, all this.
I am.
Not yet.
I'm appearing.
Well, probably he have understood that there is no case.
So,
So what do we do?
in this matter with which, any other that, Mr. Takri will appear because he can better, case belong to him. In the morning, he has requested me to appear.
Okay,
This is why I have tried my best.
but it will all be, it will be all the same.
Barely I am submitting.
As prayed for Mr. Tapak,
Tapa.
Lana Council for the, Lana Council, sorry. Mr. Tapak submits that Mr. Tapak Lana Council submits that Mr. Taki would be appearing in this case and therefore who is out of state, who is stated to be out of station at out of station, huh? Therefore pray for listing this matter after 2 weeks. Okay, prayer allowed, list it accordingly after 2 weeks.
Item number 8.
May I please submit
Yes, sir.
my note? As per the last order dated 1/6/2026, fresh
Yes.
steps was directed upon the petitioner. So we've taken the fresh steps and as per the office note, it seems the service has been complete.
This is AB.
Yes, my lord.
And
And
this
this
is
is it's a connected with, it's a POXO matter, my lord. So notice was also served.
Okay.
Highly obliged.
Obliged, man.
Item number 9.
Lordship, on last occasion, the CD was called for. It is an anticipatory bail application, Lordship.
My lord,
And-
interim may be continued.
Okay.
Interim.
In the earlier case, just a minute, in a earlier case, the interim order passed earlier shall continue till the next order listing, huh?
Deeply obliged, ma'am.
Deeply obliged, Lordship. Oh, sorry.
This is also AB,
Yes, Lordship, this is an AV.
interim,
Yes, interim
Granted.
is granted, Lordship, on last occasion.
okay, yes, what is the report has called
As
for?
per the CD, Your Lordship, after the interim, he had appeared before the IO, Your Lordship, and he was
Okay.
formally arrested and his statement was taken and he has been released, Your Lordship.
Okay,
Now, as such, his custodial interpretation is not needed in this matter, Your Lordship.
Okay.
at Present.
now what is the offense involved?
Offenses are theft by clerk, Your Lordship, criminal breach of
306,
trust.
316, and 314, Lordship.
Okay, what is 306,
Lordship, theft,
316?
Lordship, criminal, breach of trust, Lordship. And 314 is
theft.
314 and 314 is,
misappropriation
Uh,
of goods, Lordship.
Your Lordship, 306 is theft by clerk or servant, Your Lordship. 3165 is
okay.
criminal breach.
Miss D Datta. Your good name, please.
D. Doctor, Lordship.
Okay, learned counsel for the petitioner. Also heard Mr. Genie, learned additional PP for the state staff. By an order dated 11/5/2025, 26. While calling for the case study, comma, the accused applicant was protected by an interim order directing to release him in the event of his arrest in connection with the Daporejo PS case number 03/2026. Staff, huh? With the condition that he shall appear before the eye of the case within the period of 10 days. Stop. In para, it is submitted that in compliance of the direction of this court, comma, the accused, on which date he appeared?
16th of May.
On 16th May 2026, appeared before the eye of the case. Stop. Huh? On such appearance, comma, the IO arrested, IO caused him arrested. And after recording his police statement, released the accused on the strength of the interim anticipatory bail granted to him on 11/5/2026. Stop. Fair. Learned additional PP on record submits that after obtaining interim anticipatory bail, comma, the accused had appeared. And since his his statement has already been recorded and he is cooperating with the investigating agency, his further custodial interrogation is no longer required. Stop. Para. In view of the above and in view of the above submission, comma, and on perusal submission and on perusal of the record, of the case investigated by of the case under investigation and evidence collected till date, it appears that the investigation of the case is almost completed and the custodial interrogation of the accused may not be required at this stage. Stop. Considering the, no, just a minute. In view of the above, the interim anticipatory bail granted to the accused on 11/5/2026 is hereby made absolute with the absolute on the following subject to the following conditions. Stop. That the accused applicant shall continue to cooperate with and appear cooperate with the investigation of the case and appear before him as and when called for. Stop. That the accused shall not hamper the same condition. Just a minute. अच्छा, मेरा कहाँ गया? ये सब क्यों लाया? मेरा है ना? मेरा सब लाया हुआ है बैग में. Okay, that the accused applicant shall not directly or indirectly make any inducement, threat, or promise to any person acquainted with the fact of the case, the fact of the accusation against him, so as to dissuade him from disclosing such facts to the court or to any police officer. Next. So this is of which court?
Dapur, Your Lordship.
Sorry, Your Lordship.
He is resident of Dapur.
No, no.
No, Lordship, Lakhimpur.
Okay. So then
One local surety, Your Lordship, because the
no, he has
allegation
already
against
executed.
his bailer is also a local person. He'll have a security of
No,
local.
no, he has already executed.
Yes,
executed.
but only in terms of the amount, Your Lordship. The bail bond was 28,000, Your Lordship.
Lordship, 20,000,
And-
not
and-
28,000.
Mr. Thana.
20, I said 20,000.
Yes,
Mhm.
Lordship.
With
Already executed,
yes, already executed, but
Yes.
furnished.
with it was
That
only
is no longer required now.
no, Your Lordship.
Because
That is with one surety of the like nature to the satisfaction of the
Yes.
arresting authority.
that was done, already done.
The amount of bail bond of 20,000 or like amount, the surety was in terms of the bail bond amount, Your Lordship. If Your Lordship can add one surety, local surety that cannot, Your Lordship can even while making the interim absolute can always pass that order, Your Lordship, because his presence is needed. On the last occasion also, Your Lordship, he was already given the notice, Your Lordship. There was an undertaking by his wife that he'll be produced, Your Lordship. However, instead of appearing before the IO, they have come before this court.
Operation, Lordship, custodial interrogation, we have already submitted all our bank accounts, Lordship. We have also annexed it in the AB. all our transaction history.
Investigation not yet complete.
Not yet completed.
Okay.
In fact, the money that has been alleged that he has taken and the other materials from that particular place, Your Lordship, that has
Hmm.
also been not recovered, Your Lordship, and therefore
That cannot be. Okay, then, hmm. That surety he has already executed, huh? That we
Yes,
can.
Lordship. Yes, he has.
Just a
He-
minute, and also appear before the trial court agent when called for, huh?
not trial court, Your Lordship, before the arresting authority, Your Lordship. Because the charge sheet is yet.
That is there, that is already there. Then in the event of the violation of the above condition, the bail granted to the accused. No, that cannot also be. That's fine only.
Yes.
That's enough, I think.
I don't have any issue otherwise, Your Lordship. Only my submission is with regard to the local surety otherwise.
Local surety, we cannot put now. Surety already executed.
Yes, it was.
Bail already executed. He has been granted bail on execution of bail bond of rupees 28 with like amount to the satisfaction that has been done. That we cannot. And in any other condition, if there is any, if you want to add, we can.
Yes.
I think that is enough.
It should be enough, Your Lordship.
With the
Uh,
above this bail application stands disposed of. Okay.
Lordship, may I submit one more thing, Lordship? Regarding the IA, Lordship, we have, as your Lordship has directed us, we have already filed our petition with the SP. Lordship may kindly grant us the liberty to file appropriate petitions in the appropriate form. This IA shall not be barred, Lordship.
Age for what?
There was an allegation that the
Yes,
IA of the
Lordship.
case
A
has.
certain amount was extorted from me.
Wait. Certain amount?
Was extorted from me in the name of travel expenses for which the OC had incurred during his visit to Lakhimpur. Order dated 1/6/2026, Lordship will find.
Just a minute, huh? That was taken, I think. This one was not correct. What is this? I extorted 30,000.
Yes, Lordship. For that, I would like to submit that Lordship, as your Lordship had directed us on previous occasion to file a petition with the SP, we have done so. And Lordship may grant us the liberty and the IA may not be a bar for us to bar against filing a writ petition at a subsequent stage, Lordship.
Okay. So this stands disposed of.
Yes, Lordship.
Okay. Hard Miss planning council for the petitioner. Also Miss Ginny, huh? Okay. In view of the order passed today in the bail application, AB 42 AP 2026, the applicant want to withdraw this IA interlocutory application with liberty to file an appropriate application before appropriate forum. If so advised, the prayer is allowed. This IA stands dismissed from is withdrawn with liberty is prayed for. Okay.
Deeply obliged, Lordship.
Matter number 10,
But this is also an IV. On last occasion, we have granted the interim bail. And subsequently, we have appeared before IO and execute the bail bond. And I have given the statement also. And on 31 May, I have appeared before the IO.
Lordship, the city Lordship.
Okay. What is there?
Oh, Lordship, they recorded the statement, Lordship.
Okay, whether his custodial interrogation.
Since he was cooperative, Lordship, it was
Hmm.
reflected, Lordship, page number 3, Lordship,
Mhm.
starting from page 2, Lordship,
What is this?
city, Lordship.
Photo of victim.
Photo with the injury, Lordship. Offense is serious, but Lordship, since after granting Lordship interim bail, Lordship, he cooperated.
They are cooperating. What was the allegation?
Education, Lordship, pouring petrol and Fat one ally, Lordship.
Hmm.
My lord, it's,
Yes, for
it's a-
medical report, 60% body injury, Lordship.
my lordship is just a matrimonial dispute between the first wife and second wife. Out of
Okay,
that,
okay, this is the case where
Yes.
this side is alleged that it was herself,
yes,
she
ma'am.
poured herself. Okay. Have you read the statement? No. You should have read it. When this statement was recorded,
On
there
31,
is serious allegation against her. It appears.
the applicant is the husband.
Hmm.
The co-accused is my first wife. She may be the first main accused. Allegation against her.
This application is husband
Yes, ma'am.
of the victim.
Yes, my lord. The victim is the second wife.
Now, where is the victim?
The victim is in the hometown at Karsang.
With the husband or
With with her family. This incident was from 2024. In the month of
okay, the husband is not the one who done it. The allegation is against the wife.
yes, my
Mhm. Okay, so rather he tried to extinguish. Wife was granted any bail or applied for? No.
yes, she was granted on the bail.
Okay,
Session
by
court-
session.
session court.
Okay. Mr.
Nagar, learned counsel for the petitioner. Also had Mr. Loy, learned PP for the state. Staff, huh? This is an application filed under section 482 of the BNSS 2023, praying for grant of pre-arrest bail, apprehending his arrest in connection with Namtok PS case number 03/2026 under section 109 within bracket 1/118 within bracket 1/351(3) within bracket stroke by an order dated 29/5/2026. This court, while calling for the case study, has granted interim bail to the accused applicant and directed to that in the event of arrest of the accused applicant, he shall be released on interim pre-arrest bail in connection with the aforementioned PS case number 03/2026 on execution of bail bond of rupees 30,000 with a surety of like nature to the satisfaction of the arresting authority with certain conditions. Stop. Just a minute. With certain condition, including with the further condition that the accused applicant shall cooperate and appear before the eye of the case as and when called for. Stop. The learned counsel for the petitioner further submits that after obtaining the interim anticipatory bail, the accused applicant appeared before the eye of the case when 31/05/2026, and on his such appearance, he was arrested by the eye of the case in connection with the aforesaid police station case. Stop. His police statement was recorded, and after completion of all formalities, he was released on bail, interim anticipatory bail, on the strength of the order dated 29/5/2026. Stop. It is submitted that since he is cooperating with the eye of, for investigation of the case and has already been arrested and already been released on bail on execution of a bail bond, the interim anticipatory bail granted to him on 29/5/2026 be made absolute. Stop. Mr. Loy, while producing the case study and on record, submits that after obtaining anticipated interim pre-arrest bail, the accused applicant is cooperating with the investigation of the case and since his statement has already been recorded by the police
And after his arrest, subsequently he has been released on execution of a bail bond on the strength of the interim anticipatory bail granted to him on 29/5/2026, the further custodial interrogation of the accused applicant is no longer required. Staff on para. In view of the above submission and on perusal of the record, this court, and then it appears that under the fact and circumstances as stated above, the further custodial interrogation of the accused is no longer required. Moreover, the present accused is not the main accused. The record further reveals that he rather help. No, leave that, stop, In view of the above, the interim anticipatory bail granted to the accused on 29/5/2026 is hereby made absolute. Subject to the following conditions, stop, that the accused shall continue to cooperate and appear before the eye of the case as and when called for. 2, that the accused applicant shall not directly or indirectly make any inducement, threat, or promise to any person acquainted with the fact of the case so as to dissuade them from disclosing such fact either to the police or to the court. Next, that the accused applicant shall not hamper or tamper with the evidence and the witnesses of the case in any manner. And 4, that the accused applicant shall not leave the state of Arunachal Pradesh without prior information to the eye of the case till completion of the investigation. Stop. With the above, this bail application stands disposed of. Okay.
Obliged.
Item number 11.
May I please, my lord?
Yes.
My lord, on the last occasion, Siri was called for, my lord.
Yes.
My lord, in the present case, the allegation is that, my lord, some counterfeit notes were detected in the account of the accused, my lord. That was the allegation, my lord. May I take my lord to the FIR, my lord? FIR, my lord.
This
My lord,
is
I have been, yes, AB, my lord. I have been informed by the applicant that a notice was issued by the IO and he had appeared before the IO and given his statement. There was no entry, my lord.
Lordship, as per the status report, Lordship, his movement was traced by the police.
This?
His movement was, since he was absconding, Lordship, his movement was traced by the IO, Lordship,
Then
and recorded his statement because he was not arrested because he was serious health issues. So his statement was only recorded, Lordship.
he appeared and he was not arrested.
Yes, my lord, because my lord, the medical examination clearly says that he is not fit for kept in custody, my lord. Because of health issue, my lord. That must
Who says that?
that was informed by the applicant, my lord.
Okay, applicant knows that he is not fit to be kept in the
No, that the doctor has examined him.
Doctor examine.
But
on-
after appearing, he was taken to medical by the IO, my lord.
Okay, what is the comment of the IO?
Lordship, he is cooperating, Lordship.
So, okay, then what do we do?
Because, my lord, custodial interrogation is not required because the entire case is based on documentary evidence and bank records, my lord. And the bank records already with the investigation agency, my lord. So I am cooperating with the investigation, my lord.
So his arrest is not required.
Lordship. It appears from the statement of IO, Lordship. In the status report, Lordship.
What is the case about otherwise?
My lord, the present case is, my lord, the allegation is that, my lord, some counterfeit notes were detected in his bank account, my lord. The LS accused, my lord, in his bank account, my lord. The amount which was deposited was received by a person, my lord, another person, namely Mohan Bara, my lord.
His statement is there.
Yes, Lordship.
Have you gone through?
Yes, Lordship. Yellow flag mark, Lordship. The side flag.
Very long.
The allegation is that only counterfeit were detected, not in possession, my lord. Only some counterfeit were detected in his bank account, my lord.
No, Lordship. He tried to deposit.
What do you mean?
Now,
It is not possible at all.
my lord, the amount which was deposited was received by another person, my lord, by the LS accused, my lord. And after receiving the amount, my lord, he directly went to the bank and he deposited it, my lord. But he was in belief that the notes were genuine. Therefore, he went to bank and deposited, my lord. That is the case, my lord. He was totally unaware whether the notes were fake or not, my lord.
What money was that?
500 notes, my lord, domination.
How much?
Out of 40, he deposited 40,000. Out of that, 38,000 was
That 40,000, where from that 40,000?
that was received by one person, namely Mohan Bara, my lord, who is a contractor, my lord, local contractor, my lord. That was given him earlier as an advance for some construction work, my lord. But that person didn't carry out the work, so he asked him to return that money. Accordingly, he returned it. The person returned it to the LS accused. So after receiving that amount, he directly went to the bank and he deposited it, my lord.
And
Now,
now
my lord, section,
saying that he is not required to be interrogated.
because my lord,
Interrogated.
Lordship, since IO is silent on his Lordship.
Where is that? Where the IO said that his interrogation is not required in the counterfeit case?
No, he don't say-
40,000
he-
and
he-
500
he-
fake
he
notes?
didn't say that his interrogation is not required, Lordship.
What he
But
says then?
Kindly go to the bail comment.
Oh, it's long one.
Status report, Lordship. Front page from the front, Lordship. Second phase, Lordship. Para 11, Lordship.
What we'll do, we'll fix it another date.
Lordship.
Okay. Let it be, remain here,
Lordship.
since para 11 means what it says.
Status report, Lordship.
So many,
The point number 11, Lordship. I marked. Otherwise, it is serious offense, Lordship, but
my lord, that is true that the allegation is the counterfeit offense is
No,
serious, my lord.
yes.
But my
the
lord,
offense is serious, but police has made it so casual.
my lord, because my lord, section 179 and 180 clearly says that, my lord, the person must have knowledge or reason to believe that the notes were counterfeit, my lord. In this present case, my lord, the applicant is totally unaware the notes were counterfeit, my lord.
The
So
40,000 notes were 40,000.
Yes, my lord.
the intention, Lordship, they tried to deposit an ATM account, Lordship.
My lord,
Of
my lord,
ATM.
see, my lord, a person knowingly,
The case diary has been received. List it matter again on
Friday,
Friday. Friday? Okay. Hard, Mr. Huh?
Imran,
Lana counsel for the petitioner, also Mr. Also had Mr. Loy, Lanet PP, who produced the case study stuff. Since the case study has received, let this matter be list the matter again on Friday. Okay.
19. Matter number 12.
May I please, my lord?
Yes.
My lord, today it was, in fact, on the last occasion also, I sought time for the documentation.
Mhm.
So, since, till now, I have not received the documents.
Oh,
Some-
it's your case.
Lordship.
It's your case.
And then Lordship, may I pray that, this matter may be listed after vacation, Lordship?
After vacation,
Yes, Lordship, because, certain documents which
Hmm.
is, at the, at the domain of, returning officer, that could not be obtained, those official documents, and some documents which has been, enclosed in the election petition.
what I'm saying is your case. huh?
Yes, yes, Lord.
But if you make such prayer, what can we do? Okay, hard, Mr.
Etatak,
Gao, na?
etatak.
Sorry, Tatak, Land Council for the election petitioner staff. Huh? Also had Mr.
Lordship, I'm for the respondent number 1 on the behalf of K. Dabi. So we are not going to file any document.
However, there was a direction from this honorable court to file IAS for the formality of suspension. Your
Not necessary. Striking of this. There is no stay in that case.
My lord, the Indian,
Only suggested probably.
yes,
there is, Your Lordship.
What interim order was passed in this case?
yes, my lord, interim order was passed for the
Which paragraph?
continue on a bail.
Order dated 4/12, which paragraph?
It's paragraph 8 and 9, my lord. And
Okay, it's no coercive.
Yes.
yes,
Action shall be taken against a petitioner in execution of the impugned judgment and so passed by the Lionel Session Judge. And the sentence order dated and passed by the Lionel Judicial Magistrate until the next returnable date.
Yes.
But then he was
Thereafter,
directed to file interlocutory application.
yes, my
So
lord.
this is interlocutory application.
Yes, my lord.
So we'll have hearing on interlocutory
My
application.
lord, for the hearing, I want to take some time, my
When do we fix?
senior,
Monday?
I got suggestion from after the vacations, my lord.
Why after vacation?
My
Yes,
lord,
Miss Jenny.
Your Lordship, any date.
The
Your
record is any day.
Yes.
Which
my lord,
date?
this is my humble prayer. Matter should be released after the vacations. The learned council, Arsonar will be.
You want to take rest first? Okay.
Your Lordship,
Yes.
since the TCR has also come, Your Lordship.
Yes, PCR is there.
Your Lordship may call for the preparation of the paperwork, Your Lordship.
This is appeal,
No, this is a revision, but Your Lordship, they have
but then it would
challenged
be
the, yes, it would be
Okay.
necessary.
the main, huh? Miss, you,
Kiyayo,
huh?
Kiyayo, Shodayayo.
Land Council for the petitioner. Also had Miss Tijini, Land additional PP for the state staff. Huh? The file code record, age code 4 has been received. Staff, the registry shall prepare a paperwork.
Yes, Your Lordship.
And list is matter.
And my lord, the interim shall be
After,
continued.
list is matter immediately after, list is matter immediately after the ensuing summer vacation. Okay,
Obliged.
staff, the interim order passed earlier shall continue till the next date of listing. Okay.
Deep.
IA also. In view of the order passed in the criminal revision petition number 37 AP 2025, list is matter along with the said criminal revision petition on immediately after the ensuing summer vacation. Okay.
Deep.
Item number 16.
at least.
Yes.
My lord, there are two IAs, my lord. IA 192, my lord, is
Yes.
for the condonation of delay, and IA 193 is for substitution.
193 is for substitution.
Substitution. 192 is for condonation of delay.
Okay, which is to be taken first?
This both can be taken up together, my lord. Today, my lord.
Yes, you have objection in for condonation of delay? Have you filed objection? Yes. Okay. Do we have sufficient time to have hearing? This is order. We'll fix for then, Monday for hearing.
Yeah.
If both are ready, we have hardly time now. Okay,
Otherwise, my lord, I will not take. I will
okay,
not
then,
take much time.
then
Just,
how much time?
I will take 5 minutes at the most.
And you?
5 minutes.
No, that means it will go.
Okay,
It'll
my
go.
lord. Next day, my lord.
Had Mr. D. Soki, Land Council for the applicant. Also, Mr. T. Tapak, Land Council, getting on behalf of the opposite party. Start on the prayer of, on the, on being agreed by both the Land Council for the parties. Please this matter again on Monday. Okay.
22. Item number 17.
लिस्ट बनाओ हाँ 25 में ज्यादा होने से और एक ही दिन में ज्यादा नहीं करेगा.
Sorry, my lord. 22, my lord, I have some difficulty, my lord. I might not be available.
23, 24, any day then.
It's after 22, my lord.
Inform the Tapak. He has.
23, my lord, then. 23 or 24.
You have to inform him.
Yes, I will inform you. 24 then, my lord. 24 is a Wednesday, my lord.
Otherwise he will charge the court.
I will inform you.
Okay.
22, I
20.
might not.
Then we'll not fix. We'll say next week.
24 then, my lord. 24 is.
We'll say after a week. Without fixing date.
Let my lord date be fixed, my lord. Sometimes, my lord, on 24th, my lord. 23 is a Tuesday, so there might be the 24th.
24, the election matter. Count? No, no? Okay, sure. 24th.
All right.
Yes.
For fixing of date, Lord.
Yes. Okay, for the evidence of
Yeah,
the,
evidence,
okay, they need to be informed.
yes, yes. So two is basically, one is AC.
What do you want? Give date then.
Two is
next week?
basically from within Itanagar,
Then next week?
Friday, Lordship,
Friday?
19 years. OC,
This Friday?
yes, this
Okay,
Friday.
no problem.
This two witnesses, two witness.
No problem. Two witness.
Total, there are three.
How many cases are pending? They're fixed on 19.
Otherwise, it can be fixed on a Monday, Your Honor. Monday.
Monday, how many cases?
Monday, 4 matter are there.
Okay, then we'll
Lordship,
fix
what
it.
happened, there is three remain. On
Monday will be better because
Monday
they will
will-
travel on Sunday. Monday because they are
total, there
officer.
are three, Lordship.
Three?
RO, yes, one RO is on the last occasion,
Okay,
this court is allowed to be,
so that is why Monday.
Okay.
All three, call all three.
okay,
Okay. Hard Mr.
T Bagang.
T. Bagang, Land Council for the election petitioner. Also hard Mr.
MOPO.
Huh?
MOPO.
MOPO, Land Council appearing on behalf of the
Sole respondent.
respondent. or
Sole
sole
respondent.
respondent, return candidate. Stop. Okay. So,
Lordship, since
This
I have
case-
to take
this case-
steps,
Yes, I have
This
to
case
take
is
steps,
fixed.
so the steam would maybe allow.
Case is fixed
That's the
today
service.
for fixing, of the next date for evidence of the, how many witnesses you said?
3 notes. OCP,
So, okay, just a minute.
OCPS, ACB, and bank manager and RO, returning office.
The other, the one we have already started, I think.
Yes, partly we have already examined.
Okay.
Only one document has to be examined.
For completion of the evidence, further evidence of which one, which one?
OC, PS ACB, Itanagar,
Namely,
name not give.
Mipak Reba.
Yes, Ribas.
The prosecution witness number 4, and also to, no, not 4, Mipak Reba is not Mipak Reba, Sorang Yapa, Trade Development Officer.
Already done trade of
Okay, okay.
discharge already.
Okay, Mipak Reba, PW 4, and Abhijit Sutradhar, branch manager, Axis Bank, Nahalagan. And for evidence, of Abhijit Sutradhar, branch manager, Axis Bank. Only 2?
No, one RO, Lordship.
RO is
Returning
also there.
officer. Yes, on the last occasion, an IA 101 is code as placed to allow.
What is his name?
Message.
Abhijit, RO.
RO, yes, returning officer of 9 Chang Tajau Constitution.
Okay, and one more witness. By which order he was allowed to be examined?
The last occasion, last date. 29/05.
It's by order dated, Your Honor, 29/5/2020.
29/05. IA number.
It was, no, it was not through IA. Your Honor.
IA number 101.
101.
101/2026.
I don't know why all the election petitions have been fixed in one day. We should actually divide. This is first way, that is why. Which was not fixed also has been fixed. Used to.
Yes, sir.
Hmm. 10?
101. 101/26.
Okay, one more witness, the returning officer of one more official witness. That is returning officer, 9 Chang Tajau ST Assembly constituency.
whether his name was given? No,
No, not given.
it's not given your stop, huh?
Actually, they have to submit their name.
Para. As agreed upon by the parties, list is matter. When you said
22,
22,
Monday. Monday, Your Honor.
okay, 22 June, huh? 2026. For evidence of, write those three names, huh? Including the arrow, huh? First is, what was his name? PW,
Mupak Riba, you said.
hmm?
Mupak Riba.
Nipak Riba, and the other one? Council, you have to assist the court properly, huh? Court, there are a lot of IAs and all.
Yes.
And then unless you properly assist, it will take time automatically. If you can assist properly, court will have no problem passing. Order a little faster, huh? But it's your case. You throw entire responsibility upon the,
Today,
okay,
it is a fixed matter.
oh, fixed matter.
Yes,
Okay, so when do you want?
26 June,
26 June, oh, okay.
if on the
Due to
agreement of
paucity
the
time, the matter
petitioner
will not be
counsel.
heard. Accordingly, yeah, on agreed upon, as agreed upon by both the Learned Council for the parties, this is matter again on
Right.
when? 26. 26 is,
petitioner counsel is there if he agrees.
who is petition council? Who is,
VC.
yes. 26. 26 is Friday, huh?
If I may, Your Honor,
Yes.
Your Honor,
We are
in this
fixing it on 26.
if I may, 22nd, Your Honor, Monday.
22nd, is it okay?
22nd, I have outstation matter at Pasighat.
Then when, give
Can
alternate
you-
day.
29,
29,
29 is the next
29, is it okay?
Okay, Your Honor.
Okay, 29.
obliged.
If I may, Your Honor, if I may, one more thing, Your Honor. I have already filed my, additional affidavit, Your Honor, and if I've just recently known that already copies have been served to the opposite party.
You received the copy?
Yes, we have received.
Okay,
29,
No objection.
29, Your Honor.
okay, okay.
Item number
29.
19.
Deeply obliged.
Highly obliged, Your Honor.
My lord,
Yes.
my lordship. Lordship, this petition prays for passing.
Hmm?
This petition prays for passing.
Okay. So,
On the last one, teacher was called for lordship, but it appears, as per the order set, lordship, TC not received.
Lordship, all the case records, certified case records are with me. I have 3 copies.
so let him receive officially, okay?
Yes, lordship.
Your good name?
Monsoon,
Mr.
monsoon.
Learned Counsel for the petitioner. So, also had Mr. Lori, Learned PP, who submits that the trial court record. Certified, it's a scan copy.
Scan copy, Lord.
No, scan copy of the trial court record is still awaited in view of the above. And as read for comma, list this matter
On receipt of,
after receipt of the trial court record stuff. The registry shall issue reminder, huh? Okay.
Highly obliged.
Yes.
Item number 20.
My lord, this IA is for a slight modification of the order of the bail which is granted to the accused persons
Okay.
in bail application number 1441, my lord.
So,
My lord, I won't be taking much time, my lord. It's
Mr.
just this,
no time is off. It's 4:30. What bail which condition?
my lord, my lord, kindly come to para number 11, my lord. Page number 14, para number 11, my lord.
Page 14.
Yes, my lord. Page 14, para number 11. In view of the apposite's observations and findings, the alleged accused person, namely Shah Rukh Khan and Mohammad
Just a
Hasim,
minute. Page 14, para?
11, my lord,
Yes,
11.
Hmm.
So and so are granted bail in connection with Alo PS case on execution of bail bond of rupees 50,000 each with 2 local sureties, one of which shall be a government surety to the satisfaction of the learned CGM, West Siang District, Alo, subject to the following condition. My lord, this is the only thing we're seeking to amend, my lord. This 2 local sureties instead of, my lord, one local, they can be 1 local surety, and my lord, we're praying that the government surety may be from the state of Assam, my lord. The
Your prayer is?
My lord, in the bail, my lord, 2 local sureties have been imposed. One,
Yes.
yes, my
What
lord.
is your prayer?
My lord, my prayer is for, my lord, that the government surety which has been imposed may be from the state of Assam, my lord.
This says local.
Yes, my lord. But they are unable to manage because they're from outside, my lord. We'll maintain 1 local bailer, and along with it, my lord, and another, my lord, prayer is, my lord, reduction of the, my lord, surety amount, my lord. They belong to indigent condition, my lord. I have.
You have any objection?
Basing on this ground or he
Only
was
granted. Okay,
granted, Lord.
Magbo, today we have hardly we have time. So day after tomorrow?
My lord, tomorrow.
Not
My
day
lord,
after
tomorrow, my lord. My lord, because this person is has been granted bail a week earlier, my lord.
No, there is a case against him.
My lord,
Then
he has been granted a bail in a week earlier, my lord, and he has been
let him also submit. We'll see if concession, this probably this local can be, of course.
My lord, there is Supreme
Yeah,
Court
just-
judgment on this, my lord.
Yes,
The
yes.
Supreme Court
That is what I'm
judgment on
saying,
this.
can be modified, but then the other one would be
One can be local surety, and the government surety may be from the state of Assam, my lord. That is the,
state of Assam, and
Yes, my
other prayer is
my lord, that the amount may be reduced, my lord.
amount.
that is
Amount
one-
cannot be reduced. I
My lord,
think.
there is 1 lakh, my lord.
Hmm.
50 each, my lord, 1 lakh. It may be left to 25,000 each, my lord. That is
So
the
it's
only prayer.
surety only. It's a surety only. You have to sign only. You don't have to deposit cash.
My lord, because that
No,
because they belong to my lord.
Monday
My lord,
we'll take
they're
up
already
Monday.
in jail,
No,
my lord.
because
They're already in jail, my lord. They have been granted bail a week earlier, my lord. And the person also suffering, my lord. Tomorrow, my lord, tomorrow if
day after tomorrow.
my lord, tomorrow,
No, day after tomorrow is 17.
my lord, DVD,
Probably there so many cases are fixed.
my lord.
Tomorrow?
Tomorrow, my lord,
Tomorrow there is DB lordship.
my
Oh,
lord,
tomorrow
top-
DB.
top of the list, my lord. It just hardly take 5 minutes, my lord. It hardly take 5 minutes. It's just this amendment of the
No.
slight modification of the bail of the, my lord.
There is a limitation. Oh, okay. So tomorrow?
Day after
My
tomorrow,
lord,
the convenient.
Day after
my lord.
tomorrow.
My lord, I'll be out
Day after tomorrow, I think so many cases are fixed.
My lord, I'll also be out.
So when are you available?
My lord, tomorrow, my lord, it just take 5 minutes to just, my lord, only this slight.
Tomorrow? What's the problem?
My lord, top of the list, my lord.
Okay, tomorrow. On the prayer of the Lana Council for the, on the prayer of the Lana Council for the party, release it again tomorrow. Tomorrow, I think the list already prepared.
Yes, lordship.
It becomes difficult.
My lord, it's just,
You are available on Friday?
my lord, Friday will take too much time, my lord, because
No, because once you will be asking the order also. So for us also, it's difficult.
my lord,
Now it's already 4:30 plus.
After getting bail lordship. everyone-
No, you can't do that, huh?
my lord, we got a,
We'll fix it on Monday.
my lord, we got the bail a week earlier, my lord.
Maybe Monday.
But we cannot, are unable to execute, my lord. We have,
Monday,
my lord, we have been languishing in jail for, my lord, 8 months now.
maybe.
7 months now, my lord. At this point of time, my lord.
See, he is accused. He has to face certain. He has to pay for what he has done.
My lord,
There was a matter
trial,
I
my
have seen.
That can be decided after the trial, but at this point of time, my lord. My lord,
Okay.
tomorrow, tomorrow, my lord,
Tomorrow the list already prepared. They prepared a lot of list. It's unnecessary, you see, taking time. Okay.
Definitely.
my lord,
When you said
Tomorrow.
Wednesday.
list has the list come?
Tomorrow, not sure.
हाँ.
Not sure.
नहीं आया है. Okay, tomorrow. Tomorrow,
Much
let
obliged,
us try. Let us try. Okay.
Item number 21.
Your Lordship, even in item number 21, Your Lordship, this matter has kind of become infructuous because they have come on settlement, Your Lordship. And in trial court, the matter is for pending for pronouncement of judgment, Your Lordship.
In the trial court,
Yes. Since
fixed
they,
for pronouncement of judgment.
yes. And on the last,
Stayed there.
there was no stay in this matter, Your Lordship.
Let the,
Lordship, already three that has given for the judgment, yet still pending.
Your Lordship, since we are running out of time, I'll just place a judgment of
it's a
Lakshmi Narayan.
conflict.
Yes.
No, then let the matter be listed on 24th. Okay.
Problem.
यहाँ जो होगा मेरा नाम होगा ले आओ हाँ।